Morning, everybody. We're ready to go.
Can you turn off the sound?
Yes, Your Honor, the state is.
A weird balance.
Yes, Your Honor. We do have one request for a continuance.
All right. Which case?
Stephen Oki, Your Honor. We're asking to continue to tomorrow.
Any objection?
No, Your Honor.
All right, we'll see. Do you have any you're going to be requesting a continuance on?
Yes, Your Honor. Mr. Poole, we have been unable to uh, get enough information for victim contact for Marcy's Law, and so to speak with my investigator, we're still working on that, and so we would ask to continue Poole till tomorrow as well.
All right, we'll see Poole tomorrow. And okay, let's start with Anthony Johnson. On deck is Carter. Johnson, come up. All right. What does state feels appropriate on this matter?
Yes, Your Honor. Regarding Mr. Johnson, I note that he has no criminal history. It appears to me that the victim in this case indicates that while he was present and part of this, that he did not actually strike the victim during this. And so, based upon that, for Mr. Johnson, we are not going to object to an OR. However, we are going to be asking that the defendant not have any contact with Patrick Moore or the 300 Sage Street address. We're also asking that he not have any contact with the co-defendant, Mr. Galindo Cloud, and also have no weapons, given this is a crime of violence, pretrial supervision. I'm not sure, I believe I saw in his risk assessment that he did indicate that he wanted to have treatment. He was interested in substance abuse treatment per the application. So I believe based upon that, a testing for alcohol and controlled substances would be appropriate, and as well as anything else the court would like to order on that or the defense would like to see on that. And with that, I would submit it.
All right. Thank you, defense. Any objection?
Your Honor, we have no objection. We'd ask that you not impose the testing for alcohol or controlled substances. I don't believe that there's any nexus to the underlying case. Even though he does want treatment, that's something that he will pursue on his own and would submit with that.
Released on his own recognizance, no contact with Patrick Moore, the co-defendant, in the Sage Street address, no firearms. Check in with pretrial services as ordered with their supervision. Next, bail laws may go court appearances. Next Friday's your court date, February 6th at 9 a.m. We'll see that.
Being released on your own arms.
Carter and then Galindo Cloud.
Carter? He's coming, Your Honor.
All right, what's the state feels appropriate on this matter?
Yes, Your Honor. Regarding Mr. Carter, we are asking for $5,000 bail. Defendant has length of criminal history. Note it's a little more than the usual possession here at 13.2 gross grams weight of meth. I note that he had, so he's got a score of 11, criminal history going back to 2009. His first arrest was a DUI. More recently, he had a drug paraphernalia conviction in 23 where he had 90 days flat time. 22 had a misdemeanor conviction for battery that was down from domestic battery, had pretrial services violations during that case. Had a number of cases in 2021 as well, has a couple failure to appear arrests, trespass and possession of drug paraphernalia conviction, trespass and possession of drug paraphernalia, that was both in Sparks and the Reno Municipal Court. Had a failure to appear on the Reno Municipal Court where he ultimately did community court. So some services have been rendered to this defendant in the past. 2020 trespass conviction, also possession of drug paraphernalia conviction, had a 2018 drawing a deadly weapon or drawing a weapon in a deadly manner, and also obtaining money under false pretenses conviction. And then going back, it's drug paraphernalia and trespass cases. So this is an individual who has no stability in the community, has clearly longstanding issues with controlled substances, and based upon that, his understanding some of that's probably outside the consideration by the MPRA, but lengthy failure to appear history. We believe he's at risk to continue this conduct, not appear, and believe that bail is appropriate and ask that you impose it with pretrial services and testing. Thank you.
All right, thank you, defense.
Your Honor, we're requesting a release on his own recognizance. When you look at the probable cause sheet, you see that Mr. Carter was completely cooperative with law enforcement. They asked if they could see what was in his hand. He handed these things over. And I think that should be considered when you're looking at, will this person comply with release conditions? And we think the answer is yes. Although the state doesn't believe he has any ties, he does. He is living at the CARES campus and he's actively involved in community service. He is very concerned that he needs to be in contact with those individuals he's doing community service for. And our request, Your Honor, would be to release him on his own recognizance, to place conditions that you feel are necessary if he needs to check in with pretrial, and if he needs to do any sort of testing. But that would be our request, Your Honor, so that he can get back to that community service he's concerned about, and he will comply with your orders.
So it is nice that he was cooperative with law enforcement. That's certainly a good thing. The issue is, you know, the two compelling interests the government has, which is that he appears for court and that he remains crime-free. And his ties to this community, unfortunately, involve 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 cases just with the justice courts. And we're not going to see the majority of the criminal offenses that occur in the city that the defendant is alleged to have committed. And so, unfortunately, he's a higher risk to fail to appear and reoffend. And of the class of charges that reoffends and fail to appears the most, it won't surprise you that drug charges are those. And so there's statistically less than a 50% chance that he's going to remain crime-free, according to Dr. Austin's report and our internal statistics, remain crime-free and appear at all of his cases. So the state's shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant. I will, however, release him to residential treatment if that is supported by a evaluation and IAP transports him. And hopefully the help that he needs, and we can stop this revolving door with regards to the defendant and our detention facility. His next court date is going to be Friday, the 6th at 9:30 a.m. Bail laws make all court appearances. I'm not going to put drug testing. I'm putting $6,000 bail because without treatment, there's no evidence that just testing is going to be effective. I'll put pretrial monitoring, which it means that they'll give him notice of the court dates and notify us if he has any new arrests. Good luck to you, sir.
Thank you.
So $6,000.
Galindo, Cloud, and then Hutton.
Perfect. Guys, I'm gonna call you.
What the state feels appropriate on these two matters. Well, I'm
yes.
sorry, it's two different individuals, Jacob and then Ricardo. My apologies.
Yes, Your Honor. So with Mr. Galindo Cloud, we're asking for $10,000 bail. Again, this is, and we'd ask for no contact with either the victim, Patrick Moore, or the 300 Sage Street, or the co-defendant, Anthony Johnson. Also, no possession of weapons given the violence here. A couple things differ between Mr. Galindo Cloud and his co-defendant, one of which is that I note that he, I think it's in the probable cause sheet that he has that he had a juvenile hold that appears to be for a domestic battery from 2025. I can't see anything about that case, but that appears to be what that case number is about. Additionally, this defendant's actions in this case, based on the statements and the what film there was identifying them, appears to indicate that he was more actively involved in the battery of the victim. And so based upon his young age, the fact that he also has that other hold for a violence charge, as well as his more active role in this case. We do believe that that bail is necessary for the protection of the community, ensure his appearance in the future, as well as all those conditions. And with that, I'd submit, Your Honor.
Thank you, defense.
Your Honor, on the NPRA, he received a moderate score of a 6. He received 1 point for not having a cell phone. And when I talked to him, he states that he does have a cell phone. He just didn't know the number when they're filling out the NPRA, which would bring down his score to a 5 or a moderate. Mr. Galindo Cloud is 18 years old. He lives at the Eddy House, and we are requesting a release on his own recognizance. And the state brought up that he's got a hold out of the juvenile court. The juvenile court has access to a lot of resources and programs, and to put him into the place that we need to be, and this may help assist the case. So if he's released, he's not going to be released. It allows the juvenile court, if there is a program that they could transfer him into, to start with that. And we would submit with that, Your Honor.
All right. So the state has shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and appearance of the defendant was set at $10,000. No contact with 300 Sage Street, the co-defendant, the victim. Ankle bracelet in place before release to ensure compliance, as well as residential confinement, no firearms. Pretrial service supervision. However, if juvenile court does release their hold and reinstate him with all those services, then I will OR him on this case. All those conditions stay the same, plus of course complying with the juvenile court. Next court date, February 6th at 9 a.m. Garcia, Ardon, and then Hutton. What does state feel is appropriate?
Yes, Your Honor. In this case, we're asking for $50,000 bondable only bail, pretrial supervision. We prefer a scram device for constant monitoring, but some sort of daily testing at any rate, as well as no, with the pretrial supervision condition, and no use or possession of alcohol or controlled substances. What's concerning about Mr. Garcia Ardon is one, that he has a consistent, his history is only DUIs. He had a DUI arrest in 2007, which there's no disposition for that I can find. 2017, he had a conviction, essentially wet reckless, as we would know them in Reno Municipal Court, reckless driving that was down from a DUI with DUI conditions. 2022, he had a misdemeanor conviction for DUI in Reno Justice Court, and then 2024, he had a DUI second conviction in Reno Municipal Court, thus making this his third. What is also concerning, frankly, it appears that the defendant was born outside the United States, and he was telling officers that he was going to get out of jail and flee the country. So I think that given the fact that he's bumped up now in his conduct that he's had over the course of the years to felony level prison potential, and his statements that he is going to flee, I think we should take him at his word, and that shows that he's a flight risk. In addition to the rest of the community, again, as often seen with cases like this, we've gone from DUI to a DUI crash with multiple other vehicles. I believe there's 3 vehicles total. A crash caused by him, and a report from another individual that prior to that he was running over traffic cones and driving erratically leading up to this crash. So clearly a risk to the community, and therefore we believe that bail and the monitoring, if he were to make that bail, is appropriate. And with that, I'd submit it.
All right, thank you, defense.
Your Honor, for Mr. Garcia Ardon, he scored a 6 on the NPRA, and he received 2 points for having no residence. We were able to speak to Patricia this morning that confirmed that he does have a residence, that he lives at her house, and he's renting a room from her. So that would reduce his NPRA down to a 4. Patricia also confirmed that he's working at Chewy, and he's worked there for the past 2 years. So when we're looking at this case, if it's a DUI third, this isn't necessarily a case where it's going to be mandatory prison. They do have the specialty court. And one of the keys is getting a person into treatment as quickly as possible. We are in agreement with the conditions, the bail conditions set forth by the district attorney of the scrim and any other things that this court feels are necessary to keep the community safe. And this testing would know whether or not he's drinking or using. But allowing him to be released will get him into treatment as quickly as possible so that he can start that rehabilitation. And that would be our request, Your Honor, release with those conditions.
All right. So there's a considerable amount of evidence that the NPRA, a standard pretrial risk tool like this, is not valid for the DUI population. That was known before we implemented the NPRA. That's why the DUI rant is one of the boxes on our checklist. I hope we're working on hopefully getting pretrial services to do it before these hearings, not after, but we'll continue to work on that. So like the last case, I'm kind of going to do a mix of what you both are suggesting, because the state, certainly the defendant's criminal history has shown that he's a high risk to reoffend. An individual that engages in the same conduct over and over again, especially with the chance of being arrested and convicted of a DUI being so incredibly low. And then we also know that if you're going to be killed by a stranger in this country, it's going to be by someone like the defendant, an impaired driver. You're not likely to be murdered by a stranger. It's more likely this individual is going to kill you on the way home or a way out with your family. And so he posed a grave risk, frankly, to the community. Now, the defense is right. That risk may be monitored and reduced, which under least restrictive means analysis I have to consider. So here's my order. Bail will be $50,000 because the state has shown by clinical convincing evidence that bail is necessary to ensure the safety of the community and appearance of the defendant. I'm going to mark that as interim. He can have a new hearing after we have a substance use and mental health evaluation so that we have some sort of plan before we release him, rather than release him and tell him to go get an evaluation or treatment. Because in this court, we see virtually every day individuals that have been told to get an evaluation and don't do it. So he's going to have to do that ahead of time. One of the conditions that the felony DUI court has is residential confinement. They also have daily alcohol testing, random drug testing. So those will all be ordered. The DUI rant, as I mentioned. Mutual support groups, the evidence is very clear, incredibly effective in reducing recidivism. They're also free in case the defendant has a financial burden to treatment. So daily mutual support group meetings until in treatment supported by an evaluation. Pretrial services supervision, obey all laws, make all court appearances. February 6th at 9:30 a.m. Defendant's next court date. We'll see you back then.
6 is your next court date. You're gonna get some evals so I can read.
Hutton and then White.
Okay, it's 50,000 next Friday. Next Friday. No, you gotta make bail. 50,000.
All right, let's see if it was appropriate on this matter.
Yes, sir. In this case, we're asking for $10,000 bail, pretrial supervision, no contact with, I believe it's Miss Sally, S-A-L-I-E, who's the victim in this case. The defendant has linked criminal history going back to 2010. Most recently convicted for possession of drug paraphernalia in Reno Justice Court in 24. Had a gross misdemeanor conviction for unlawful use of 911 in 24 that appears to have had a result of a dishonorable discharge when I looked at that case. 2022, a misdemeanor conviction for petty larceny. 2021, had a couple probation violation arrests. 2019, a misdemeanor conviction for DUI. 2018, a misdemeanor conviction for possession of drug paraphernalia. And then 2014 and 2010, misdemeanor convictions for obstructing. So clearly has had these kind of as we see with these types of charges, kind of adjacent to substance abuse issues, given that kind of recent, 24 conviction, as well as the lengthy history of possession of drug paraphernalia and substance abuse. We're also asking for testing for alcohol and controlled substances with a pretrial supervision. And with that, I would submit it.
I think it does.
Thank you, Your Honor. Again, starting with the NPRA, she initially received an 11. She received 1 point for not having a phone. We were able to talk to her grandpa, Bobby, and confirmed her phone number. So we do have an actual phone number for her. She received 2 points for not having a residence. Again, we talked to Bobby Hutton. He confirmed that the client can live with him at 9,000 Turbine Way. And she also received 1 point for not having employment. When we're talking to Bobby Hutton, he confirmed that she works at Zane Investigations Towing Company. So with this new information, it would take her down to a moderate risk of a 7. Another thing that this court can look at is what is the likelihood of conviction in this case? Although we only have the probable cause sheet, it appears that the reason that the police were searching the car was because a canine alerted for the positive presence of controlled substances. And I don't quite understand how, with a positive alert for controlled substances, you start reading credit cards and the names that are on a person's credit cards and why they're going through a wallet in such a manner. So whether or not it was lawful for them to enter into that purse, that wallet, start reading the names of credit cards and doing those things, those are things that are going to have to be addressed in further issues in court. But we do bring that up, that there may be issues with the whole basis for the search in this case. And with that, Your Honor, we are requesting a release on her own recognizance. We are agreeable to the bail conditions that the state has set forth. She's agreeable to drug and alcohol testing and will comply with all conditions that this court imposes, and would submit with that, Your Honor.
Right, she appears to do well with supervision, so I'll release her on her own cognizance, no contact. Random drug and alcohol testing, pretrial services supervision, next court date, February 6th, 9 a.m. Obey all laws, make all court appearances.
Sorry, would that be, you said February 6th? Would that be the?
I did.
Okay.
That's gonna be for all of them. Every case. White. And then Blakely.
Morning.
Good morning. State feels appropriate on this matter.
Yes, sir. In this case, we are asking for $5,000 bail, pretrial supervision, as well as testing for alcohol and controlled substances. Concerning for the defendant, had an outstanding warrant. I understand that we had a cylindrical container, but said it was 10.8 gross grams weight of the suspected fentanyl, which is a concerning amount of fentanyl, depending on how large the packaging was. But this defendant has part of his concerning criminal history. So he had 2025, 2 arrests for failure to appear, also had an arrest for resisting the don't show disposition for. 2023 had a failure to appear on a municipal court traffic site. He has charges going back to 2010 in California, had an open container conviction in that year, then had a misdemeanor conviction in 2011 for receiving stolen property, and then had a under the influence possession of drug paraphernalia arrest in 2014 that looks like it was ultimately dismissed. At least it was closed out in that fashion. So an individual who has longstanding drug issues apparent by his criminal history, has failed to appear on even some of the small stuff with the Reno Municipal Court, but then again, relative lack of ties to the community. It appears that he's only been here since probably 2023. And given the kind of facts and circumstances that, again, there was a burglary report here indicative of kind of victimizing others in the crime or in the community to pursue controlled substances, and overall evinces a lack of stability in the community, which in the state's view will lead to more failures to appear. And so we believe that bail is appropriate, as well as the supervision and testing. Thank you.
All right, thank you. Defense?
Your Honor, this is similar to the case that we argued earlier where here, Mr. White had an arrest warrant. When officers asked him if he had anything that was going to stick them, poke them, anything, he was completely open and honest and turn over what is suspected to be fentanyl. Mr. White is interested in treatment. He wants treatment and he needs treatment. We would be requesting a release on his own recognizance so that he could go get that treatment on his own with bail conditions such as testing, checking in with pretrial supervision. But if this court would like to have a more direct transport, we would ask that this court order that he can be directly transported into treatment, and would submit with that, Your Honor.
All right, because he scores a higher risk to reoffend or fail to appear, The state has that compelling interest that I have to consider. Therefore, the state showed by convincing evidence that bail is necessary to ensure the safety of the community appearance of the defendant. And I'll also order the OR to residential. So the bail is going to be $6,000 on this case. Random drug and alcohol testing, DA supervisional bail, as make court appearances, OR to residential treatment if supported by an evaluation and IAP transports. Obey all laws, make all court appearances. We'll see you at on the 6th at 9:30 a.m., sir. Blakely? And after Blakely's Moreno. What's the state feels appropriate on this matter?
Yes, Your Honor. In this case, we're asking for $20,000 bondable only bail, given the charges here. The defendant has a lengthy criminal history. Concerningly, he was convicted in 2021 for burglary of a business. He looks like so he had that burglary of a business charge. He picked that up while he was pending a possession of controlled substance case that originated in 2020, wherein he was sent to a program, looks like pending the outcome of the case. He was sent to Salvation Army. He walked away from that, then picked up the burglary of a business. So he was convicted of both the possession of controlled substance out of the 2020 case and the 2021 burglary of a business. It looks like he did successfully graduate drug court as a condition of his probation on those cases in 2023. But again, as an individual who has experienced quite a bit of support and recently, some of the highest supervision this court or a court in this jurisdiction can offer. And here we are just a couple of years after he graduated from drug court with what is more concerning as far as a residential burglary allegation, as well as the controlled substances again. His history goes back to 1994. He had a drug case at that point where he was granted diversion. So again, multiple attempts at assisting his controlled substance issues in his past. He had a 94 case in San Jose, as well as a 95 case in Alameda County, California. It says he was granted diversion. It looks like that was probably the same diversion case, although they were different dates, so it may have been a couple diversions. 97, he was convicted of burglary, as well as possession of a controlled substance and carrying a concealed weapon in Campbell, California. Then had a 99 possession of a controlled substance felony conviction in Santa Clara. Had a felony conviction in 2003 for burglary in Santa Clara. Had one felony burglary and one misdemeanor conviction in Santa Clara. Those appear to be two different cases that were both resolved in Santa Clara. He appears in Reno in 2012 with a possession of drug paraphernalia conviction. He had a misdemeanor conviction for stalking in 2013, where it looks like he violated his probation, was sent to the gospel mission. Again, another attempt to address his drug issues. Also had a misdemeanor conviction for DUI in 2013, had a misdemeanor conviction for breach of the peace in 2015. So an individual who has a history replete with burglary convictions, both in the state and in California, as well as multiple attempts at substance abuse treatment that appear to not have done the job. And so therefore, at this time, the state's view, this defendant is a risk to continue this type of conduct as replete in his history with both burglarizing members of the community as well as drug use. And so we'd ask for that $20,000 bondable only, pretrial supervision, testing for alcohol and controlled substances if he were to make that. And then, no contact with the 1375 Mill Street, I believe.
All right.
Yes. Sorry. Thank you.
That's
Your Honor, we are asking for a release on his own recognizance. Again, when you're looking at the charges, you can look at the likelihood of conviction. A residential burglary, when police talked to him, he said he went in there to have a warm place to stay. So there's no showing that he went in there with any sort of intent to take any sort of items. When he was in there, granted, this is a residence that no one was living in at the time. So I think that that's something that could be taken into consideration when you're looking at whether or not he could be released. Mr. Blakely has been suffering. He's been telling me he's gone blind in one eye. He is homeless. And if released on his own recognizance, his plan would be that he would go to the shelter. In the alternative, if you would consider allowing him to get a substance abuse evaluation and go back into those treatment programs, it seems like it's been quite a while. And Mr. Blakely's been through a lot of hardships in his life, including losing his mother that he moved here with, and he really has no family left. So we're hoping to get him into that treatment program so he can get some support that he needs in his life.
all right. The state showed by clear and convincing evidence of bail outside the defendant's ability to make it is necessary to ensure the safety of the community. The appearance of the defendant set at $25,000, no contact. As requested, random drug and alcohol testing, pretrial services supervision, no bail laws, make a court appearance February 6th at 9 a.m. And the distinction here with this defendant is the fraud and theft related offenses and the open warrant as opposed to the others that I've released on their own recognizance. Those things, I think, change the calculation. We'll see you next week, sir.
Thank you.
Moreno. Let's see if it's appropriate on this matter.
Yes, Your Honor. So with Mr. Moreno, we are asking for $5,000 bail, pretrial supervision, as well as testing for alcohol and controlled substances. The defendant's history appears to be, it's all out of California. His criminal history goes back to the year 2000. In that year, he had a misdemeanor conviction for essentially domestic battery. He had another arrest for battery in that year. Looks like it was ultimately dismissed. Had a DUI conviction in 2004. That was in Lodi, California. Had an arrest in 2007 for possession and transporting a controlled substance. That looks like it was ultimately pled to possession of a controlled substance. That was in Calaveras, California. Looks like he went to prison on that case. He had a 2014 rape charge in Stockton that looks like it was ultimately dismissed. And then has a number of traffic issues that looks like they were ultimately resolved as citations. Then in 2017 had a take vehicle without consent felony conviction in Stockton, California. Had another 2018 take vehicle without consent felony conviction in Stanislaus, California. And then has a few traffic cases after that. It looks like he had to be extradited back to finish, and then had as his last case in California that I see is a 2020 Stockton case for grand theft and theft from an elder or dependent. It looks like that may have been dismissed at some point, though. It looks like it was closed out in 2024. So an individual whose history indicates long-term substance abuse. He appears to have come to sorry, he has a couple arrests, but no convictions, starting in 2021 for possession of drug paraphernalia in Carson City. But that is his only Nevada connection, except for this case, as far as the state can tell for sure. So based upon that lengthy history, risk to continue this conduct, lack of ties to the community, we believe he's a risk not to appear as well. We would ask for that bail as well as pretrial supervision and testing. Thank you.
I think it depends.
Your Honor, on the NPRA, he received an 8. He received points for not having a cell phone in a residence. Although we weren't able to contact a reference because he couldn't remember anyone's numbers, they're all in his cell phone. He didn't have access to it. He did tell me that he actually has a cell phone and he was able to give me the number. He also informed me that he would live at 5041 Catalina Drive, apartment 1 in Reno if he were to be released. So that would lower his NPRA score down to a 5, which is more of a moderate. We are requesting a release on his own recognizance. He will comply with any sort of conditions that this court feels is necessary. And we would ask in the alternative, if you're not willing to release him today, that you allow him to be OR'd to that inpatient program as well, because there were controlled substances.
All right, I'll give him a chance, given that maybe he is only a moderate risk, and I think he gets the benefit of the doubt. Random drug and alcohol testing, obey all laws, medical court appearances, pretrial services supervision, next court date, February 6th at 9 a.m. We'll see him then. Anybody else over the jail?
No, Your Honor.